Thank you, Patrick. Well, thank you, everyone, for coming, including half of Scheef & Stone's Frisco office and a good portion of the Dallas office. I appreciate you coming out. Again, my name is Jeff Mullins. I am a corporate attorney, and it's very nice to be among what I would call real lawyers. Recently, we had celebrated my nephew's 32nd birthday, and it's shocking to me that I am old enough to have a 32-year-old nephew. And I remember one of the conversations we had when he was much younger, and I was as well, and I was trying to explain to him what exactly it was that I did as a corporate attorney. And it was very, very difficult because they don't make shows about what we do. And I think people are not really interested in seeing people draft contracts or negotiate over the phone. But we kept going, and finally he had had enough, and he said, well, how about this? How often do you go to court? And I'm like, I never go to court. And he's like, not good enough, huh? Right? So it's great to be with real lawyers, to be with good lawyers. And I appreciate the opportunity to speak to you today. I've spoken to litigators before, and it's always difficult for me to figure out what might be a topic of interest. But I think here's one that actually would be of interest to most attorneys, whether litigators or transactional attorneys. And as Patrick mentioned, the title of my presentation today is, What Do You Mean I'm Personally Liable? Avoiding and Capitalizing on the Consequences of Business Entity Forfeitures. All right, so what are we talking about when we talk about business entity forfeitures? All right, well, a business entity is basically something other than an individual that does business. So we're talking about a corporation, we're talking about an LLC, talking about a limited partnership, basically most entities that you would encounter. All right, well, what's a business entity forfeiture? And we're going to talk about two different types of forfeitures today. One is a loss of the right to do business in Texas. If it's a corporation, it's called corporate privileges or the right to transact business in Texas. You might hear that often referred to as being in good standing. Okay, so that's one type of forfeiture. We're also going to talk about terminations of charter, if you're a domestic entity, or termination of your registration to do business in Texas if you're a foreign entity. All right, now, in and of itself, that does not sound exciting. And maybe you won't find this exciting anyway, but it's something that should be of interest to us because, one, as litigators, as plaintiff's attorneys, there are real opportunities for you to take advantage of the consequences of the business entity forfeitures. Some you may be aware of, some may not. But even in other situations, transactional attorneys, defense attorneys, there are things that we can inform our clients about and really serve them by telling them about what these consequences are and give them some practical tips about how they can avoid it. All right, so I am a Sunday school teacher, and one of the things that I like to do when I teach Sunday school is start out and give you a main takeaway at the very beginning. What do I want you to take away from this presentation today? How do I want you to think about that topic? All right, I'm going to do this with an illustration. I want you to think about butterflies. Okay, not really, but we got a butterfly there. Okay, now who knows what this is right here? That's right, it's two very angry tornadoes, okay? So when you're talking about copyright, license-free images, you're a little bit limited, right? All right, so now why would I have on the screen a butterfly and two angry tornadoes? I mean, what's the connection between the two, if any? Doppler effect? Anyone else heard this before? Absolutely. It's the consequence of a business forfeiture, right? All right, so there is something called the butterfly effect. And this was actually this scenario was first talked about in a Ray Bradbury novel. And the basic idea is that small causes can have large effects. And the way it usually works, and although the animals and the catastrophe that happens changes from story to story, is there's usually a butterfly butterfly in Brazil. I've heard the Indian Ocean. I don't know what a butterfly would be doing in the Indian Ocean, but is there, flaps their wings, and then halfway around the world, because of the changes in the atmospheric pressure and the domino effect, there's a tornado in Texas or Oklahoma, because that's where they happen, right? All right, so the idea is that small causes can have large effects. Well, that's going to be our main takeaway today, is that small oversights can lead to big consequences. When it comes to business entity forfeitures, small oversights can lead to big consequences. Why do I say oversights? Okay, well, we're going to see that there's some bad things that happen if you don't pay attention with your clicker, but there are some bad things that happen when you don't fulfill your obligations under law. Now, there are probably some people out there that say, hey, I'm just not going to pay my franchise taxes. I'm not going to follow the law. There are other people who probably say, well, you know what, I'm not really doing anything with this entity anymore. I'm just going to let it go away. But I think the vast majority of this problem is led by people just overlooking some very simple things that they can do, and it can lead to very large consequences. Okay, so we're going to start out and spend most of our time with forfeitures under the tax code, okay? Now, there are two stages in forfeitures under the tax code, and we're going to spend most of our time on the first one. But what are we talking about with the tax code? Well, specifically, we're talking about Chapter 171 of the tax code, which deals with franchise taxes. All right? So a franchise tax is imposed on each taxable entity that is formed in Texas or does business in Texas. So whether you're foreign or domestic. And taxable entity, not surprisingly, is defined very broadly, right? They're trying to get taxes, okay? There are some exclusions, but basically when you think about taxable entity, just about any entity you think of is going to be included. The amount of tax varies, but for a lot of people, there's not going to be any tax at all. You can see if the amount of your total revenue is less than or equal to $1,100,000, you're not going to pay any tax. Well, think about all the entities that are out there. Think about how many that make less than $1,100,000 in a year. So you have a lot of entities that are not going to have any tax due. Now, notwithstanding that, regardless of whether any tax is due, each taxable entity has to file a franchise tax report. If any taxes are due, they've got to pay their taxes. And they've also got to file a public information report. And again, that's regardless of whether any tax is due, and a lot of people don't do that. And that's what's supposed to happen. Now, there's this little problem here, and this problem is called mail, right? So we've had many advances over the last 20 years. When I started out as an attorney, we could not use email, and the last 2 hours of my day were putting together mail packages, FedEx, to go out because we couldn't use email. But even with the ability to use email and electronic communications, we still use mail. And that is exactly how the controller sends out these franchise tax notices, right? They send them out by mail. Now, the problem with mail is you have to have one thing in particular for the mail to get there. What's that? You have to have a good address. Now, you might be surprised to know this, but a lot of our clients and a lot of companies don't keep their address up to date with the Secretary of State or the Controller, and it can have really big problems. It reminds me of an incident from my foolish youth where I moved and I did not update my address with Rhodes College, where I did my undergrad. Now, for some reason, I had my bigger student loans, but I paid $30 a month to Rhodes College, and I didn't update my address. And as it turns out, I didn't get my notices, and I went 6 months without paying them. Okay? When I finally realized this, I had a notification that I had been reported to the credit agencies and had a 180-day plus note on my credit report. And also, I found out, I immediately wrote a check for the whole thing, paid it all off. I wrote a letter to the Director of Financial Aid and got a letter back that said, sorry, you should have paid it. You should have kept your address up to date. So a couple of things happened. One, they did not get a donation for many, many years. It was my fault, but that was a terse response. The second thing is it killed my credit. 2 years later, and this was a long time ago, I'm much more responsible now. 2 years later, my credit was at 620, and it took 7 years for this to come off. So not keeping your address up to date, I think, leads to a lot of these problems. So what happens here? So there's stage one, forfeiture of the corporate privileges, or think of losing good standing. So if you don't file your report on time, or if you don't pay your tax, you're going to get a notice from the controller. Now, bless you, generally your report, your public information report, your tax is going to be due on May 15th, all right? Sometimes people get an extension, but it's generally going to be due on May 15th. If you don't file on May 15th, they're going to send you a notice of forfeiture, and if you don't file your required reports, pay your taxes, they're going to forfeit your corporate privileges. Okay, well, what happens if you forfeit your corporate privileges? Well, one note before we go on is when we talk about corporate privileges, the tax code is very clear that this does not just apply to corporations. All right, so this applies to LLCs, it applies to limited partnerships as well. Okay, so when we're talking about corporations here, also think other taxable entities. So LLCs, limited partnerships. When we're talking in a minute about directors and officers, think managers of a manager-managed LLC. Okay, members of a member-managed. All right, so little quiz here. How many tax forfeitures were there in 2012? Let's see if this is a problem. Were there none, right? About 1,000? Well, I've just spent about 10 minutes talking about what a big issue this is, so probably not. Were there 5,000 tax forfeitures? Were there 25,000 or 75,000? What do you think? 75. Yeah, 76,377 to be exact. All right, so this is happening a lot. I called them this morning to try to get updated information. I can only imagine that the numbers have grown higher because people are not getting more responsible and we keep forming more and more entities. So the lesson from it, there are some opportunities to take advantage of these negative consequences. Well, what are they? Well, there's two big consequences. Let's start with a lesser one first. All right, first of all, if you forfeit your corporate privileges, you're not allowed the right to sue or defend in a Texas court. Now, there are a few caveats to this. Okay, number one, this doesn't apply to prevent you from defending a suit to forfeit your charter or your ability to do business in Texas. Okay, that's one thing. Also, despite the clear language, Texas courts have said if you forfeit your privileges, you can still defend claims that are against you, right? I'm not exactly sure how they got that because it clearly says you don't have the right to defend. Maybe it's an issue of fairness, but you do have the right to defend. All right. Courts have also interpreted this section to preclude only filing suit after you forfeited your right to do business, not from continuing an action that was filed before. And finally, in a suit that arose before the forfeiture, affirmative relief may not be granted to the corporation unless corporate privileges are revived. So, any questions so far? Yeah, Brian.
Second, third one,
how do those square with each other? In what way?
The second one.
So there's the second one right there. So you can always defend a claim, okay? Yeah, Jim. Okay. Okay, so we have here that if you brought a suit before you forfeited your right, you can continue that suit, okay? Now, what's that? That's right. That's right. You can't.
You can continue your suit. Okay.
Right. All right. So, first consequence, pretty big consequence. Now, here's the big consequence, and I think the one that most clients don't know about, because when I've mentioned it to them, especially if they have this issue, they get really bothered about it, okay? The second consequence is each director or officer of the corporation becomes liable for certain debts of the corporation, okay? So, what are we talking about here? Well, what kind of liability? Like they're a general partner in a general partnership. They become jointly and severally liable, all right? Now, what does that mean? Well, it means just what I said, jointly and severally liable, right? There are some exclusions we'll talk about in just a minute, but they become liable for those particular debts. Now, which debt? All right, this is the big topic. So each debt that is created or incurred in the state of Texas after the date on which the report, tax, or penalty is due and before the corporate privileges are revived. And this includes any franchise taxes or penalties that come after. Now, you might think, and a lot of people do think, that this personal liability does not arise until the corporate privileges are forfeited, but that isn't true. If your franchise tax report, if your public information report, if your taxes were due on May 15th and you forfeit in July, your liability extends to debts that were created or incurred in Texas the very next day after you should have filed, so May 16 of that year, okay? So, what's a debt? Well, there's no current definition. From 1987 to 2008, what the controller and the legislator were trying to do is cut down on ways for companies to deduct from the amount they had to pay tax on. So they said, okay, because companies were out there and saying, well, we've got this contingent liability, we have this unfixed loss. So what they did is they said debt is going to be any legally enforceable obligation measured in a certain amount of money which must be paid or performed within an ascertainable period of time. It's a very narrow definition because they were trying to prevent exclusions. Now, this was used in some of the cases that were interpreting this personal liability, but this definition was repealed back in 2008. I don't think it's going to apply anymore, and there's no current definition in Chapter 171 of the tax code. So I think debt is going to be determined very broadly. Yeah?
You mentioned each director or officer of the corporation. Would that apply to managers of an LLC?
Yeah, absolutely.
Members of an LLC?
Only if it's member managed. So if you don't know, with an LLC, you can have a manager managed LLC plus have members or member managed. So it's not going to apply to someone who is just an owner. They've got to be in some kind of managerial capacity. Okay, any other questions at this point? Yeah, Jim.
Some LLCs don't have members, right?
I'm not aware of a LLC not having a member. Now, there is a yeah, there is a provision that says for a reasonable period of time after formation, you don't have to have members, but the idea is you do eventually have to have members. So, okay. Are there any defenses to this? This is a big question that your clients, their officers, directors are going to have. Well, the burden of proof is going to be on the director, the officer, the manager. They've got to show that the debt was incurred or created over their objection. So they're going to have to show proof that they objected to it, or they're going to have to show that this was done without their knowledge, and that if they had exercised reasonable diligence, they couldn't have known about it, okay? So there are defenses there. I'm not a litigator. You guys are probably more creative than me. I don't like my chances very much with that one. But another thing, if this came up, one of the things that I would point to, and I've not seen this discussed in any of the cases, but the intent seems to be that you had to be an officer or director at the time. Because if you look back at the liability of a partner, which is the type of liability directors and officers have, it excludes liabilities that arose before they became partners, that relate to an act or omission prior to when they became a partner, or that was under a contract or commitment entered into prior to their admission. Okay? So I would argue, even though I haven't seen cases, that if they were not a director or officer at the time, that would be a defense as well. I just haven't seen case law on that. Any questions? Okay. Now, here's one. What if the corporate privileges are revived? And the good thing is, you can revive it. The controller is still happy to take your money, right? So you can revive the corporate privileges if before the charter or the certificate of authority is forfeited by paying any tax, penalty, or interest due, filing the necessary reports. Now, that solves the problem, right? Well, it reminds me of something that happened to me earlier. My family and I went to Disney World back in early May, and we got lucky because the day that we came home, the water heater in our house burst. And yes, this is lucky, right? I can look at it this way now. The water heater burst and it flooded all through above our master bedroom ceiling. And we had to get that fixed. And it was expensive, even though it wasn't much damage. But we had it fixed, and once it was fixed, it was like it never even happened. There's actually a company, we didn't use them, that does home restorations that says, like it never even happened. Well, unfortunately, that doesn't apply here. And here's a big deal. If the director or officer has liability based on forfeiture of corporate privileges, that's not affected by the liability. It sticks with them. Now think about that. If you're an officer or director, and from May 15th, and let's say you find it out in December, you have liability for every debt incurred or created by your company during that time period, and you can't do anything about it. That's a horrible, horrible result, and it's not one that you want to have to tell your client. Unless your client is suing a company and you want to add the officers and directors. And then this is wonderful news, right? Do you guys like to, litigators, do you like to have additional defendants to add? Do you like to be able to sue the decision makers so they lose sleep at night, right? Do you like to be able to tell them that there's nothing you can do about this? I should have been a litigator, maybe. Maybe not. Yeah, Jim.
Okay. Debt created, forfeiture.
Mm-hmm.
Then 6 months goes by and revival.
Mm-hmm.
You telling me that the directors are liable for all three of the debts that were created before the forfeiture, and they can't get rid of it by reviving the corporation?
So from the due date, so let's say you forfeited because you didn't file your return on May 15th. For anything incurred or created from May 16th through the time of revival, they are liable for. And you can't do
revival does not.
it. Does not.
But they're also liable, if they don't revive, they're liable for every debt the corporation ever created, right? Even before the termination or the forfeiture.
No.
So if they don't create new liabilities after forfeiture, there's no liability for the officers and directors?
That's right. That's
So
right.
you just let the corporation just go
Well,
away and
but
they're liable?
there probably are going to be, other liabilities that come up. So, for example,
They were liable for everything that happened even before revival.
no, they're not.
Like kind of a recurring contract.
Yeah, and so I've got some examples that will cover that particular question. Here's basically the three important points on the timeline. So first, whenever the obligation was due, okay? Then when you have the privileges forfeited, then when they're revived. So the question becomes, when are debts created or incurred? That is the big question that the cases deal with, is at what point? Because if the debt was created or incurred over here, okay, no problem, right? Okay, so when are debts created or incurred? Well, the Texas Supreme Court dealt with this back in 1946 in the case of Schwab v. Schlumberger. And basically they said these words, created, incurred, have very clear meanings, and you can just read the meanings there. If you're asking your 15-year-old to define created or incurred, they'd probably come up with something similar after giving you a weird look, right? So we have these meanings. So basically, a debt is created when it's brought into existence, when it didn't exist before, and it was incurred when it was occasioned or caused. So in that case, we come to our first example. In April 1st of 1939, there was a promissory note executed, okay? July of 1940, forfeiture of corporate privileges, so sometime before their due date would have occurred. Then sometime thereafter, there was a renewal note that was executed, all right? Now, was the director or officer liable under this renewal note? What do you think? How many people say yes? Okay, how many people say no? Okay. All right. Okay. So the Supreme Court actually said, no, there was no liability, that the execution of the renewal note did not create or incur a new debt. It merely created new evidence of the existing indebtedness. So basically, it was just renewed, it was just extended, it wasn't creating a new debt. All right, second situation. Employment agreement was executed in November of 1992. There was a forfeiture under the tax code, and there's the answer, and the officers and directors were sued for personal liability for payments that were due under the employment agreement that were due after the forfeiture. All right? They were not paid. So, were the officers, directors liable for the payments under the employment agreement that became due after the forfeiture? Who thinks no? Who thinks yes? Okay. Well, the courts again said no. Right? You guys are doing okay, 0 for 2. We've got one more example, right? So the court concluded that the debts were created or incurred in 1992 when the employment agreement was signed. These payments were already called for when the employment agreement was executed, so because of that, they were created or incurred at that time. And that was in the Court of Appeals in Dallas. That's Beasley case, and it's the relation back doctrine. And so what you're seeing there is that if you have a breach of an obligation and that obligation was incurred before, the courts are going to say, no, we're going to relate back and the debt is going to be created or incurred at the time the contract was executed. Okay, one more, and I am positive that you're going to get this. December 2007, lease agreement executed. November 15th, 2008, franchise taxes were due but not paid. August 26, 2009, amendment to the lease agreement that added an option to purchase the property. Corporate privileges were forfeited in 2009. Now, the option was exercised, but the deal was never closed. And the officer and director was included. The plaintiff said that they should be personally liable for a breach of the option to purchase. All right. Who thinks the director or officer was liable in that case? Jim? Who thinks they were not? Actually, yes, in this case. Yes, because the court concluded that the debt was created or incurred in 2009 when the lease amendment was signed. So what's happening here? Okay, the option to purchase did not exist when the lease agreement was signed. It did not exist before the due date. It did not exist until after the due date. And because of that, right, even though there was an original contract in place, that option never existed before. Okay? Couple of open things. A recent case has left open for future determination whether non-contractual claims such as tort claims, statutory violations can lead to liability under that particular section of the code. Some cases have said that no, it doesn't apply to tort liability. I think it's really an open question at this point. Yeah, Brian.
When you say left it open, how do they get around the decision?
Well, they were dealing with a contractual matter, and this is one where they went through kind of the history of this type of liability, which has been around for a long, long time, including in predecessor sections. And basically said, we don't really need to determine whether that's the case. What's interesting is there is at least one case out there where someone brought tort claims, and the court said, yeah, you've styled those as tort claims, but they're really related to the contract. And so you can see, even though there's this liability of officers and directors, there's also, the courts are keeping that, making it a little bit less dangerous because of they're keeping it when the original contract is signed. Now, if you sign a contract after the due date and then you forfeit, you got a problem. It's just in cases like these where you've got an existing obligation where some of the questions come up. Any questions before we move on?
Did you find any, I envision like a premises where someone stubs their toe and falls down and sues after the entity's already?
I did not see one, but I would guess that there is a good possibility that if that happened after the date the franchise tax report was due, or if they didn't pay the taxes or the public, I would guess, I haven't seen a case that says this, but I would guess that that debt would be created or incurred after that time, and there could be some liability. There have been some courts, though, that have said that this doesn't apply to tort claims, so it's really an open question. All right, so here are some practice tips from Jeff, the non-litigator. All right, so if you have any others, let me know what you think. But first, tips how to capitalize on this. Now, I'm sure your mind has already been working about how to capitalize on it, right? But here's the first one. When you have a case, go to the controller's website, there's the address, see if they're in good standing. Now, it used to say good standing, but now it calls it active, all right? I don't know why they changed that. I thought good standing was fine. But if it says anything other than active, like inactive, go ahead and add the officers and directors as defendants, okay? Number 2, all right, let's say you go and your defendant entity is active. It's in good standing. You're out of luck, right? Not necessarily. I did not know about this until recently, but you can actually, so franchise tax returns and the information in them actually are confidential. But whether or not they were timely filed, whether or not there have been forfeitures, is not. So you can make an open records request. You can do it by fax, by mail. You can go down to Austin if you want to. Or you can do an email, and you can find out relevant information. And I actually did this just to see if it would work. So 2 weeks ago, Wednesday the 5th, I decided to do a request on one of my clients that wouldn't mind. And I said, hey, I'm interested in doing an open records request on such and such entity. This is their Texas taxpayer number. And I would like for you to tell me whether or not they've ever forfeited their privileges. If they did, when were the due dates that they failed to meet, and when they were revived. And I didn't hear anything, and you get an email back that says, we'll be in touch soon to let you know the status of your request. And they never did that. And I was like, well, that's kind of a bummer. That would have been nice to have. But lo and behold, Monday, I got it back. And what happened is in just over a week of getting my request, they had done this letter. This was from last Thursday, and they sent it to me. And they sent me this form. It's actually got a nice gold foil stamp on it. And it goes through, and unfortunately, because this is one of my clients, it says, client was forfeited on this date, and it was revived on this date. Forfeited on this date, revived on this date. But good news, as of now, as of October 13th, it's in good standing. So, what you do is when you're in a lawsuit, do an open records request like this. If you think for some reason there's not going to be sufficient funds, or if maybe you want to add a little pressure, do an open records request. It took 12 days for me to get it back, and that's some good information. There's more information about this on the controller's website, and I'm glad I actually called them this morning, and I'm glad I did because I had been pronouncing it comptroller, and they said controller, so in case you didn't know as well. So you can find more information at the controller's website. All right, what about avoiding the consequences of loss of corporate privileges? Well, the first one, inform your clients. Let them know about this issue, and let them know about the potential personal liability of officers and directors. I remember there was a time in my career where I was going to start up my own firm, and I read this book, How to Start and Build a Law Practice by J. Thunberg, and it was a great book. And he said, one of the difficult things for you to do when you're starting out your practice is to send out bills, right? Who likes to send out bills to their clients? Well, it's a necessary evil, right? Because they can't pay the bill if they don't get it. It's kind of like their franchise tax notices, okay? So what he said is keep on your desk a picture of your wife, your spouse, your children, your boat, your lake house, your Maserati, right? And whenever you get worried about sending that bill out, look at that picture. Whatever you need to do, talk to the client's officer director about if you represent officer directors, whatever they care about, let them know that's at risk, okay? Second thing, way to endear yourself to the client. Set a reminder on your calendar for mid-April to remind clients of the upcoming May 15th deadline. This is something that's real easy to do, and you can actually put it on your bill and say no charge, and you can tell them why this is important, and they'll think you're a really great guy, and they'll want to pay all your future bills because you're bringing such value.
Is it always May 15th for everything?
It's not. So when you form a new entity, you might have a different due date for your initial report. But typically, once you get past that first period of time, it's going to be on May 15th. Now, you can request an extension to November 15th. That's another thing you might inform the clients about. I'm not sure how often the controller grants those, but you can get an extension. Robert, do you have any idea how often or how willing they are to?
It's not an automatic extension, it is within the comptroller's discretion.
Okay. All right, next tip. Advise clients to appoint a responsible person as registered agent. Now, this is very important. An entity cannot appoint itself as registered agent. It can have one of its employees be an agent, but if you do that, make sure that it's your star employee. Don't think this is something that you can just give to anyone. Has anyone seen Office Space? You remember how the two consultants, the two Bobs, come in and they're talking to this one guy and they're trying to figure out exactly what he did, and he really didn't do anything except talk with the customers because the engineers didn't have people skills, right? This is not the guy that you want to be your registered agent, okay? Now, there is going to be some pressure from some of your clients because they don't want to put someone in their own organization. There's going to be some pressure for you to be registered agent. Now, this is just us talking as lawyers here. Don't do it. Do not be registered agent for your client. Now, I know I have some friends, probably some in this room, that disagree with me, that say, hey, I want to be the first one to know if something goes wrong, okay? But two things. One, if you do this for a number of clients, you've got to forward the mail on to them, you've got to do your correspondence, you've got to take some time to do it, and I really don't feel right about billing for that, because I think if a client sees you doing that, they're probably going to get irritated. The bigger reason, though, is just imagine if something happens, right? Just imagine that you're the registered agent, and for some reason, whatever that is, you don't get it to your client, and your client forfeits, and the directors have personal liability. That's not great client relations, okay? And this can be a problem. I've been at firms where I'll go into the mailroom, because what people don't do is lawyers that do this don't typically say, Jeff Mullins is the registered agent. They will say, Scheef and Stone is the registered agent. Well, what happens is all these franchise tax notices go to the mailroom. Now, do you think the person in the mailroom knows who client X belongs to? All right? Now, maybe they talk with accounting or whoever, but there's a chance that it doesn't get there. I was really persuaded not to do this for something that happened to me 6 years ago, and luckily it turned out okay. We had formed a company, and I agreed to act as registered agent. And several months later, the treasurer said, hey, Jeff, what's up with this? Do you want us to forfeit our corporate privileges? What's going on here? I'm like, what are you talking about? He's like, well, we didn't get our franchise tax notice. I'm like, well, we didn't get it either. Well, years later, one of our employees was terminated, and I was looking in one of her file cabinets, and lo and behold, there was that notice to the client, and it got stuck in a drawer. And luckily, this did not turn out badly, but it could have. And I just wonder, is any type of benefit that your client gets worth the chance that you will be responsible for them forfeiting their corporate privileges and having personal liability? So what should you do instead? There are people who actually are in the business of being registered agents. It's not that expensive. It's about $100, $150 a year, and they will send it to your client. They cut you out as middleman. You don't need to worry about it. Another caveat, though, even that's not perfect, right? So advise clients to put processes in place to update the registered agent when that person leaves, because people leave, right? Or when you move your office, all right? Have some type of procedure in place to help you remember. Now, even if you have Capital Services, for example, as your registered agent, you think, well, I'm safe because they're probably not going to move, and if they do, they're going to send one big notice to the Comptroller and the Secretary of State. Well, the problem with that is when you have Capital Services as a registered agent, you fill out a business information sheet that lets them know who they should send the information to. So that information could change. So make sure clients have processes in place. Finally, stress personal liability of directors and officers. Let them know this is a problem. And another thing you can do is from time to time for some of your clients, just go through, see if they're in good standing or not. Okay, before we move on, we're going to do some practice tips for if you have director, officer, manager, for helping them to avoid personal liability. Now, just thinking about this, there's really no perfect way, right? Because what director or officer signs every contract, right? I worked in-house at a hedge fund for a few years, and there was one person who signed everything. Great idea, right? And the lawyer that reviewed it had to put their initials there, so there was accountability. That's not most places, all right? But prior to signing a contract, particularly a big contract, it would behoove your client or you to make sure that they are in good standing, that they are active. If you're about to sign a big contract, your client's about to sign a big contract, check to see if they're in good standing. If they are not, tell them not to sign that contract until they're back in good standing. Most of the time, it doesn't take a lot of time to get back in good standing. All right? 2.
Is that part of the due diligence you do when you're doing a transaction? One of the things you always check?
Well, one of the things the contract will say, a lot of them do, especially in the M&A merger and acquisition, is that you're currently in good standing, right? Yeah, and so you will check. But let's say you're doing a license agreement or something along those lines, or a loan agreement. You'll get those representations, but does that always get checked? No. And so I think it would be a good idea for especially those of us who represent clients who are signing contracts to make it a practice to check. And really, you should only have to check a certain number of times a year. All right?
Even if the defendant whips out a contract and says, look, the reps, it says we're in good standing, doesn't mean they are.
No, it doesn't. I mean, it's either they are or they aren't, aren't, and the controller makes the decision about that.
I had a client that did that exact scenario, Jim, where they said they weren't good standing, had all the PIRs submitted, and it turns out they had been forfeited because the registry agent had left. And I think that they give them about 3 months, I believe, to replace it. And if that doesn't happen, there's forfeiture on those grounds. And we notified the client because there was this window. They said, no, here's all the PIRs, here's all the no tax due reports and all that stuff. And it was for Brown and completely unbeknownst to the client.
Yeah. Yeah. So you can also have, like my hedge fund that I work for, you can have them establish policies regarding the execution of contracts, who has the authority to sign, who must approve, things like that. It's not a fail-safe, but have the officer, director, manager regularly request in writing from the people in their company information about the contract that they might be signing. So I have one client, I do a lot of contract work, and they know what contracts are in their pipeline. All right? Officer and director sends emails out, hey, what are we signing? What are we doing? Basically, you're doing things along with the policies, the procedures, your emails. Remember, there are defenses, okay? So if you objected to it, all right, well, you got to know about it to be able to object to it, all right? Also, defense is if you don't know about it and you can show that you acted in a reasonable manner to become acquainted with the affairs of the company. So you try to do those things. Now this one I would like to think works, but I don't think there's any way this would work. You could advise your client that's a director or officer to send a letter to the entity's board of directors, officers, saying that you object to the execution of any contract at any time while the company is not in good standing. I don't think that will work, by itself, but it might be helpful because this law was really put in place to penalize people who knowingly incurred obligations on behalf of the company after the corporate privileges. So, might not hurt. One last tip that's not on here. So, public information reports. When we spoke earlier, we talked about how they're due May 15th each year, along with the franchise tax report. Now, there's very basic information on the public information report. And as the name would imply, it's public, right? You can go to the Secretary of State's website and you can look that up. Now, it's going to tell you some information. Most people don't fill them out properly. You're supposed to say, who are your 10% owners? Who do you own 10%? Nobody does that. Nobody does that. But you're also supposed to say who your governing persons are, your officers and directors. Well, enterprising plaintiff attorneys who want to add officers and directors as defendants, I'm guessing you guys will go to the Secretary of State's website and we'll look at the public information reports. Is that part of what you do? Okay. So one of the things, if you have a client that is a director or an officer and they leave, have them send a letter to their former employer and saying, next time the public information report comes around, make sure that you don't list me, okay? Because this happens. So I had a client a number of years ago that Mitch Little, some of you may know, we were doing some work with, and he was the sole shareholder, sole director, sole officer, and he sold his company, okay? The person that bought it decided to drill some wells, and they were supposed to plug them, they didn't plug them, and they got some liability. So the Attorney General has said, well, we need to recover these costs for plugging the wells and also for these penalties. So who are we going to sue because this company is no longer in existence? Well, they go through to the most recent public information report. And guess whose name was there? Even though he had not been an officer or director for well over 2 years, his name was there. Okay. Now, how do you get yourself removed? Well, this is not perfect, but if they file the next public information report and they list your client as an officer or a director for an entity for a public information report covering a period of time for which they're not in that capacity, you can have your client file a sworn statement with the controller saying that you are not an officer or director at that time. The controller will send it on to the Secretary of State, and then they will adjust the information that's on the website. That's not perfect, because in this situation, the last public information report that was filed was the one that my client had filed, right? He was clearly a director and an officer during that period of time. So there was no way to remove him because the most recent one was accurate, right? So luckily for my client, we were dealing with someone very understanding at the Attorney General's office. But another thing to do is be careful about those public information reports. So we're at about 5 to noon, and I didn't think I was going to have enough to talk about, and we've just kind of scratched the surface of this topic. But really, this is really kind of the meat of the topic. One more thing I'll talk about before we take some questions is a very strange result, okay? Because, you know, as we know with Toyota, and I know from living in Austin back in the early 2000s, it's not just Texans here, right? We have people coming from all over. They all want to live in Texas. So, not all companies doing business in Texas are Texas companies. We have Delaware corporations. We have Nevada corporations, right? All right. Now, here, entities who fail to register in Texas, a really, really strange and what I think is an inequitable result. All right? Most foreign entities that transact business in Texas are required to register to do business in Texas with the Secretary of State. All right? So you get your certificate of authority. If you do business here, you're supposed to register to do business here. One of the big reasons is so they know about it, so they can charge franchise taxes, right? Well, sometimes foreign companies don't do that, right? And there are consequences to that. So, the foreign entity will not be able to maintain a suit on a cause of action arising out of business transacted in Texas in a Texas court, okay? However, they do have the right to defend. Now, they also could be enjoined by the Attorney General suit from doing business in Texas. They also can be penalized for not being registered. But here's the real kicker, all right? So check this one out right here. All right. If a foreign entity, a foreign corporation, fails to register to do business in Texas, that will not cause any owner, member, or managerial official of the foreign entity to become liable for the debts, obligations, or liabilities of the foreign entity. So think about this. Let's take Delaware Corporation. Let's say it's Jeff Corporation. Jeff is a very responsible corporate citizen, okay? Jeff registers to do business in Texas. But Jeff didn't do a good job following Jeff Mullins' advice, and he has a forfeiture of his corporate privileges. All right? Now, what happens to the officers and directors? They get liability, right? Now, let's take a foreign corporation, another Delaware corporation. Let's call it Sean Corporation. All right? Sean Corporation is a scofflaw. Sean Corporation comes in and does business in Texas and never registers in the first place. Now, Sean Corporation may get a slap on the wrist, but Sean Corporation's directors and officers don't have personal liability. Now, why is this? Because personal liability only attaches when you forfeit your right to do business in Texas. And if you didn't have the right to do business in Texas in first place, you can't forfeit it. That seems really inequitable to me, but something to bear in mind if you're dealing with a foreign entity.
I wonder if the legislature, you know, as a matter of comity with the other states, I mean, I don't know what other states require as far as foreign registrations, imposing or lack thereof, imposing personal liability, but I wonder if they just considered it in totality with the other states and said, you know, like for example, I don't know what Delaware does, but kind of a state-specific thing, I would think. So I don't know if that just was balanced.
Yeah, I don't know why, and it's very clear. It's not even a case that it's not covered. I mean, there's specific statutory language that says it. So I don't really know why, and it seems unfair to me because both companies are doing business in Texas, but one has a negative consequence because they follow the rules, and admittedly, they didn't file a report or pay a tax. The other one didn't do what they were supposed to. They don't have that liability. So.
On the last slide,
Mm-hmm.
managerial officials, that include directors?
Yep, that's going to be directors, that's going to be officers of a corporation, right? So that's a case where you don't have it. So if they were never registered in the first place, seems really unfair to me, but they don't have that liability because they can't forfeit their corporate privileges because you can't lose what you didn't have in the first place. We're at 12:59, and I've got about a million more slides. We haven't even touched forfeitures or terminations of charters. But frankly, this is really the meat and the best part of this. I hope you have enjoyed the presentation today.